Just because you got arrested for DUI doesn't mean you're guilty. State of Oklahoma, the government has the burden of proof that you are in fact guilty of your DUI charge. But let's start from the beginning. If you were arrested for a DUI, there's a good chance that you're going to be taken into the state's test, either the breathalyzer or a blood draw, to begin the process of evaluating what your blood alcohol content, or BAC, actually was at the time that you were arrested. After you're arrested, you'll go to the county lockup at some point. You'll have an opportunity to make a phone call. We would encourage you to bond out of jail. And then the court process starts. Law enforcement will take their police report on your alleged DUI, turn it over to the government, and the prosecutor will start evaluating whether or not they're going to file charges against you. It's crucial that you contact and begin working with an experienced DUI attorney as soon as possible, because the earlier you do that, the more your attorney has the opportunity to attack your case. There's preservation of evidence issues. There's the opportunity to make sure that your lawyer is able to get everything that exists in your case. The earlier you get in contact with a DUI defense attorney, the greater the chances are that you can fight your case. When you're arrested for a DUI in Oklahoma, you really have two separate cases going at the same time. You have the criminal case for your DUI that's greatly impacted by the recent decision of Senate Bill 54, and then you separately have your civil case. On the civil side, the sooner you contact an attorney, the better, because there's an opportunity to contest the government's process for suspending your license or work through the government's program of the IDAP, but you only have 30 days in order to contest the driver's license process from the date of your arrest. On the other side of the criminal case, it's crucial that you and your DUI defense attorney work to preserve evidence as quickly as possible, because it can not only positively impact you fighting the case, but it can also help on your civil case as well. DUI case is a unique animal because it has science, it has facts, it has evidence, and it has the law. And all of them are interplaying at the same time. Was the initial traffic stop valid? Is there a reason to kick out everything that happened afterwards through a suppression motion? Were the tests that were conducted or not conducted done appropriately? Are they admissible? Are they scientifically valid? And on and on and on through the process, it's important that you and your attorney work together. On the criminal side of your case, after your charges are submitted to the district attorney's office, they'll make a decision on whether they're going to file criminal charges against you, and if so, what criminal charges. Once you go to court, you'll have an arraignment and then an initial appearance on either a misdemeanor or felony. It's crucial that you're working with an experienced DUI attorney from the very beginning, because they can be working not only on your case, but on the prosecution throughout this process. By working with an experienced DUI attorney from the beginning, they can help you in preparing for fighting your case, or alternatively, if you want to work out an agreement, whether it is a diversion program or by a plea agreement with the government. But both of these processes are happening at the same time, and it's crucial that you are prepared when you go to court. A field sobriety test consists of 3 pieces which are conducted on the side of the road by law enforcement to evaluate whether you have signs of intoxication. As a defense attorney, I can tell you it is never in your interest to take a field sobriety test. A field sobriety test is a tool that the government uses to try and show that you're in fact guilty of a DUI. You should never take a field sobriety test on the side of the road. These tests are designed to show elements of intoxication or perceived expressions that law enforcement try and show are intoxication. There are 3 parts to the field sobriety test. None of them are designed to help you. The field sobriety test consists of 3 different elements. There's the walk and turn, there is the horizontal gaze nystagmus test, and there is the one-leg stand. All of these tools, law enforcement are evaluating every element of what you're doing, what you say, how you look, how you stand, and trying to pick up clues or cues that they can write down to allege that you're intoxicated, and here's why. The field sobriety test is a tool for the government to show that you're intoxicated, whether or not you actually are. The courts have said that driving on a public road is a privilege and not a right. And so the government has tools that they can enforce upon us when it comes to driving on public roads. Anytime that you are pulled over and arrested for suspicion of DUI or APC, or actual physical control of a motor vehicle while intoxicated, the government automatically notifies DPS related to your driver's license. At that point, the shot clock as it relates to your driver's license starts, and it's only 30 days. At that point, you have to either decide if you're going to work through the government's program, IDAP, to voluntarily participate in all the requirements that they place upon you to keep your driver's license in state, or if you want to exercise your right to fight the government and go through the appeal process to contest the driver's license revocation. In all cases, especially DUIs, knowledge is power. When we work with the DUI client, we try and find out everything we can about the case. It's not necessarily what happened, but what they can prove. And so we evaluate everything from the police report, the dash cam video, body cam video, the science, the reports, everything in the government's case, and work with our on-staff investigator to help build your defense. I hope this overview to DUI defense has been helpful for you or a loved one facing DUI in Oklahoma. I'm John Cannon, your fierce advocates at Cannon Associates, and if you have questions, we've got answers for you related to DUI. I encourage you to reach out today for a free confidential case strategy session and get answers to your DUI questions now.